the one that we'll cover today, involving Elgert and home hardware. We want to help you understand what happened in that case so that you can avoid similar issues in your workplace. So let me tell you about Elgert. He was a manager at a warehouse and had been there for 17 years. He loved his job. He enjoyed making sure that the shelves were stocked and that inventory was taken and accurate, and that his workers could find the products that they needed and get them delivered to the retail outlets that were ordering these goods. So Elgert was a happy camper, and he had on his team a female employee, and it came to his attention that this employee, she happened to have a crush on one of her coworkers. And at some level, Elgert thought, well, this is cute. But it became a problem for him when this employee got so distracted that she basically stopped doing her work. She wanted to kind of park her cart in the same aisle as her boyfriend and work side by side with him. When she was stationed somewhere else, she would often take breaks and be wherever her boyfriend was so she could converse with him. And while Elgert thought this was cute, he ultimately needed her to do her job. And so he did what a responsible manager would do, and he tried to performance manage her. So what happened with Elgert was he told this worker that he needs her to do her job, and she's got to be more productive. And when she wasn't responding to that and improving her productivity, he decided, look, I need to just, write you up. And so that's what he did, gave her a performance review, wrote down his negative comments, and reassigned her to another part of the workplace. This did not sit well with this young worker, and she made it known to others that she was going to she was going to make Elgert pay for this decision that he had made. And it so turns out that this young worker, her dad was Elgert's boss. So you can see how this is shaping up, and it's not looking too good for Elgert. Happens a short while after this girl is reassigned to another part of the warehouse, that a bunch of coworkers are out at a Boston Pizza having drinks one night, and one coworker starts talking about maybe how a little bit odd Elgert was, and how he had chest bumped her in the workplace one day. And so apparently when Elgert and some of the other male colleagues got together, when they were excited and amped up, they would chest bump each other, and so this was maybe okay amongst the guys, but this one female worker thought it was a little odd when Elgert did the chest bump or belly bump to her. And this colleague who had been reassigned, she remembered she had actually had a similar experience with Elgert 4 or 5 months before, where he had done the same thing. It wasn't a problem then, but now she was looking at this incident saying, hey, maybe this is sexual harassment. And she took that issue to her father. Her father had been with the company for several decades, and he was upset by the news that his daughter brought to him. And he spoke to his friend in human resources who had been with the company for a few decades as well. And what happened next was an investigation was put in place, and that quickly went downhill. And so we want to take you through those missteps and make sure that you can learn from the example in home hardware and avoid making those similar mistakes in your investigations going forward. So the first issue that we're going to look at, the first misstep, is hiding from the incident. We'll then cover jumping to conclusions. We'll look at the mistake of maneuvering and not listening to witnesses and parties. We'll then turn to choosing the wrong investigator, failing to keep records or adequate records. And then finally, after the investigation, failing to make a conclusion on one or more of the allegations. Finally, at the end of the presentation, we will reserve time for questions and answers, and we'll also present you with a QR code that we would love for you to scan. So if you enjoyed today's presentation and this information was helpful to you, we would really appreciate if you would scan that QR code and leave a positive review for us. My name is Dorian Persaud. I am the senior lawyer at Persaud Employment Law. We are a team of lawyers who specialize in conducting investigations and helping you to build healthy workplaces through investigations, training, and proactive advice. So the first issue that we're going to, misstep that we're going to look at is hiding from the incident. And hiding from a problem does not make it better. It does not make it go away. That issue hides in the dark and it just gets bigger. When you are presented with an issue of misconduct, right, whether that is bullying or sexual harassment, whatever the case might be, you want to make sure that you respond to that right away. There is a duty to investigate, and you want to make sure that you are investigating these complaints in a timely manner, right? You don't want to wait, 6 months or 4 to 6 months before you look into it. You want to look into it, soon after the events in question have occurred, and you want to make sure that you are putting in place a fair process, right? That's going to get at the heart of the issue and figure out what happened here. So we see this duty to investigate early on it first appeared in human rights decisions, right? So the way that tribunals across the country would look at this was investigations are a means to an end. How would you know if there's been discrimination or sexual harassment in a given circumstance unless you look into it? And I was part of a case where we represented a university in a human rights case where it was alleged by this professor that he was discriminated against on the basis of age. So he was saying, I didn't get this tenure track position. I did not get this job because the university deemed me to be too old for the position. We were able to successfully defend against that and demonstrate that the candidate who was hired was head and shoulders a better candidate than this person who had brought the application. And that was the only reason that she was hired into that role. It had absolutely nothing to do with age. And we were successful in achieving that outcome for the university. But the tribunal, although they decided in our client's favor, they still awarded $5,000 in damages to this applicant, because what they found was the university didn't take the complaint seriously enough and didn't investigate it to make sure that there wasn't, in fact, any discrimination. They took it on face value, knowing their process and the hiring process that had been implemented. They assumed and at a high level understood that there wasn't any discrimination here, but they had a duty to do more and to dig into this a little bit more than they did. And there was that nominal amount of damages that were awarded to the individual. Since that time, since the time of that case, what we've seen is a number of legislative changes, mainly to occupational health and safety legislation at the provincial level and at the federal level, mandating that employers investigate allegations of harassment and bullying and sexual harassment in the workplace. So you have an obligation to look into these issues you have that legislative obligation to look into these issues. Many of you will also have policies that will require that an investigation be done. So if there's an allegation of nepotism or a conflict of interest, you might have a policy that would require that issue be looked into. And you want to make sure that you're following those policies as well, right? Because at the end of the day, that policy and whether or not you conduct an investigation, it's a reflection of your values. And to the extent that you don't follow through on whatever the policy indicates should happen, employees pick up on that. And they see that the policies really don't have any teeth, and these things exist, but they don't have any meaning. And And that can take hold in a workplace over time and cause people to look externally for a solution. And you end up having these situations which could be resolved informally, but because folks don't believe anything will be done, they look for an external solution. And again, that's just escalating these issues results in unnecessary expense to both sides. The other misstep that I'd like to review with you is jumping to conclusions. So when you think about a fair investigation and a fair process, it requires a few different things, right? One of them is having a neutral and unbiased investigator. The investigator is not coming into this work with any agenda except to figure out what happened here. That's his or her only agenda, is to determine the truth of the matter. In addition, you want to make sure that the parties know the allegations that are going to be pursued, right? So this goes for both sides. For the complainant, you want to know, here are the allegations that I made, and this is what the investigator will be looking into. For the responding party, similarly, you want to know, here are the allegations that have been made against me, and you want to know what is it that I need to respond to and answer to when I am meeting with the investigator. And finally, it's an opportunity to be heard, right? You want to make sure as an investigator, you're not just taking a piece of paper that the complainant has provided and assuming that, oh, this encapsulates all of their complaint and all of the issues and all the nuances of this complaint and just run off and then, start interviewing the respondent and other witnesses. You want to make sure that you've listened to their story, that you understand and that you've got the complete story before you then begin the process. And similarly, with the respondent, you want to make sure that they have adequate time to both prepare for an interview and then to give their evidence and let you know who else you might need to meet with before you reach a conclusion on the allegations that have been made. One of the biggest mistakes that we see is just the prejudgment of an issue to the point where you don't really have an investigation at all, right? And this can be an easy mistake to make, because when you are working with folks and you've maybe worked with them for some time, you get to know different people, and you might have for example a complainant who is a frequent flyer. You've got someone who complains about everything. And so when this complaint comes in, you're thinking, well, this is just more of the same. She complained about this thing last month, and here we are again. She's complaining about something similar. So it's easy to dismiss. Or if we look at a responding party, someone might have been accused of bullying students in the past, and here they are, and similar allegations are being made now. So yeah, obviously they did it. Let's just we don't want to spend the time and the energy and the money to look into this issue. We have a good sense as far as what's happened here. Let's reach our conclusions and move on to the next step. And that's a mistake, right? When you jump to conclusions and prejudge the issue, that can lead to some negative outcomes and often expensive outcomes for the employer. Which brings us back to our friend Elgert, right? You see that he has, reassigned the boss's daughter to a position that she doesn't appreciate. She and another coworker have had a discussion now about, this chest bumping or belly bumping that, could be sexual harassment. And that then gets reported to the father, who then takes it to Human Resources. Human Resources receives the complaint from the father and decides to run with it. They basically accepted on face value what was reported to them, met with the daughter to determine, to verify some of the information that they received, but it wasn't entirely clear at trial to what extent they took information or received evidence from the daughter directly and received that firsthand evidence, or to what facts and what evidence that they receive and accept from the father. So it looks like a lot of the story that was then conveyed to the HR manager at the outset by this girl's father was accepted as fact, and that was the basis on which this HR manager moved on. So you can see then if we're aiming for a neutral investigation, you've already got from the outset of this one this this HR manager maneuvering, right? He's not interested in listening even to what exactly happened, right? He's already got the story, and now he's shifted gears to how do I maneuver Elgert into a position of discipline and ultimately out of this organization. And if you find yourself in that situation where you're looking at the investigation as a way to maneuver someone into discipline, or the investigation is a pretext for dismissal, you need to identify that bias, right, and check that bias and ask yourself if you're the person that should be doing that investigation, because again, you're setting yourself up for what is a flawed process and could end up costing the employer a significant amount of money. The other issue that we see in this case is, again, a leaning and not listening, right? A key element of a fair investigation is giving the parties an opportunity to be heard, right? They have a chance to tell their story. You're entering that room and you don't have an agenda except to listen to their story and figure out what happened. And if you aren't giving equal time to the parties, and if you're not actually listening to their story, then again, you're setting yourself up for a flawed outcome, and potentially costly litigation. So what we see in this case is this HR manager, taking the information that he's been presented with, meeting with the other lady who complained that she was also chest bumped to confirm what had happened to her, and then basically pulling Elgert into a meeting. And poor Elgert has no idea what's going on at this stage. He just gets called into a meeting, and he is accused of sexual harassment. And he's sitting there just dumbfounded. He's like, "What? Sexually harassed who?" He's like, "What are you talking about? What is the thing that I'm accused of doing? Like, what is the behavior? Like, what is the sexual harassment? What conduct did I engage in that is sexual harassment?" No details given. He's like, "Who does this involve? Like, who is accusing me of this?" No details given. So he's called into this meeting, accused of sexual harassment, not given any details about what he did and who he allegedly did it to or when these incidents occurred. He's just told, you know what, you know what you did. You should know what we're talking about. We don't need to explain this to you. And Elgert is in tears. He's literally in tears at this meeting, and he's begging for details. He is begging for answers. He's saying, look, somebody's out to get me. You need to investigate this. Like, you need to actually look into this, because this is a false allegation. And they basically show him out the door. And that's the beginning of the end of Elgert's employment relationship with Home Hardware. So you have in that meeting, there's no listening at all, right? They're not even asking the questions to elicit an answer. They're not providing any details in that meeting. They're simply making an accusation, keeping the responding party in the dark, and ignoring what Elgert's saying about, you need to speak with these people. You got to, do an investigation. Here's some people that I think you might want to meet with to figure out what's happening here. The HR manager is not interested in any of that. What can't be missed in this case as well is, just the relationships, right, of all these people involved. You've got the daughter who was disciplined and reassigned by Elgert, and she then complains to her father, who takes issue with the allegations of sexual harassment, and points out to the HR manager that we've got a zero tolerance policy at Home Hardware for this behavior. And the two of them have worked for decades, right, for Home Hardware. And at no point in time did anyone step back to analyze all of these relationships that the senior manager who's approaching HR. It's actually his daughter that is implicated and involved as a complainant in these allegations. No one looks at the relationship between the HR manager and this senior manager. Nobody looks at within the warehouse itself the relationships there. So that's that's something that warrants a second look. You have to be aware of those angles, and there are many examples beyond home hardware where you basically have friends investigating friends, and what you want to do as an employer is to make sure that you're putting in place a process that ultimately is going to stand up to scrutiny. And one of the ways that you stand up to scrutiny is to show that there's no bias, right? There's no actual bias in the investigation, and also that there's no appearance of bias, right? So, a reasonable person looking at this investigation can say, yeah, you know what, this person, they got a fair shake in this. Looking at this situation, I don't think there's anyone that would look at the situation and say that Elgert is getting a fair shake. And so that is definitely something that was concerning to the court. So when you're doing investigations, again, making sure that you're checking your bias and at different points along the way, just making sure that you are that this process or the evidence that's come out, or maybe the relationships involved, even during the investigation, that you're aware of these different angles, especially when it's being conducted internally, right? Because sometimes you go into an investigation and you're not sure of who all the witnesses are. You might know who the party is, right? Because you have the name of a person who filed a complaint. So you might be aware of that person, but you might not be aware that, a key witness is someone who, I as the investigator am on really good terms with, or this, key witness is a person here whose evidence I might be relying on. And, because of that and because of our relationship, it may look as though the scales are tipped, one way or the other. So sometimes it's at the beginning of the investigation that you are doing this work of identifying bias and potential bias. You're also doing that during the investigation as evidence becomes known and witnesses become known. Another issue that we often see is choosing the wrong investigator. So that was another misstep that Home Hardware made here. Beyond the fact that the HR manager was really good friends with the complainant's father, in this case, the evidence was that the HR manager had never actually done a sexual harassment investigation. So here was this sexual harassment complaint involving at least two employees, and the person assigned to investigate has never done a sexual harassment investigation. As we talked about before, these situations have serious outcomes. When you have someone in the workplace who's accused of sexual harassment and there are multiple victims, there will be consequences if these allegations are founded. You have to be aware of that at the front end of the investigation and make sure that you have someone doing the investigation that's equipped to do it. You can send someone in to do this serious job where someone's employment and reputation hangs in the balance. You can't send somebody in to do that job who doesn't have the tools or the experience to do that job, right? So we all have to start out somewhere. And if you have got someone junior that you want to train on how to do an investigation, Home Hardware in this case could have identified the lack of experience, and maybe they had someone else in-house who could be the lead on this, and the HR manager could have shadowed that person, or they could have just simply referred this out to an external investigator. But that was a serious misstep on their part to throw someone into the fire like this, to conduct this sexual harassment investigation, who didn't know where to start, who didn't appreciate the nuances of that of the fact scenario and the steps that should be followed and how to approach those interviews and how to conduct that investigation in a way that would be fair to the parties and that would stand up to scrutiny. So these are things that you want to be mindful of as you're determining whether or not to investigate a matter in-house or looking at how to do them externally. Choosing the wrong investigator can lead to serious consequences for the organization. And in this case, as I mentioned, not only did this person not have any experience conducting a sexual harassment investigation, but it was actually described at trial that this was the most serious allegation that the company had ever faced to this point in time, right? So you're not just being faced with low-level allegations. This is the most serious allegations that have ever come across HR's desk, and they didn't think to send someone experienced in to conduct that work. The final misstep that I wanted to review with you, the second last misstep that I wanted to review with you is that of secrecy. And we can all appreciate that in investigations, confidentiality is important, right? You have to maintain confidentiality and preserve the reputations of all those involved. But there's a difference between secrecy and confidentiality. So you want to make sure that the parties are aware that they're not to discuss with anyone else what the contents of their discussion with the investigator. That stays within that room. And similarly, at the end of the investigation, when the conclusions are announced, those are announced to the parties involved, and that information is not shared broadly to everyone in the workplace or even everyone who may have participated as a witness in the investigation. But maintaining confidentiality over the contents and the conclusions is a very different thing than keeping the allegations themselves secret and keeping them secret from the responding party. You can't call someone into a meeting. In this case, we have Elgert called into a meeting, accused of sexual harassment and never told, and given details about what happened and who was involved and where it occurred and when it occurred, and giving him an opportunity to respond to that. So we highly discourage investigations by ambush, and certainly even to the extent that there is a view out there that you get better information if you don't let people prepare and you call them into a meeting and just hit them with the allegation and see how they respond in the moment. There is that view out there. I don't share that view, but there is that view out there. But even in that instance, in that circumstance, you still can't keep the allegation itself secret. You can't say to someone, "You're guilty of sexual harassment," and you know what you did. You have to explain what occurred and give that person a fair opportunity to respond to the actual allegations that have been made. The other misstep that I'd like to review with you is a failure to keep records. So we talked about the fact that there are important rights at stake in a workplace investigation. Someone is accused, in this case, of sexual harassment. If those allegations are founded, that person's employment hangs in the balance. You want to make sure that you are putting in place a fair process, one that is free from bias, and you also want to make sure that you are keeping records of that process. So if at the end of the day you're challenged, right? Because if this person is dismissed, very likely they're going to file a lawsuit for wrongful dismissal, and you'll end up in some sort of litigation. Even if the individual is unionized, you're going to have a grievance that may likely end up in front of an arbitrator contesting the person's discipline or dismissal. So you want to have records of what was the process that you followed. So you want to document as the investigator, whether this is internal or you're using an external investigator, make sure that that person is documenting the steps that they followed from beginning to end. There should be a section in the investigation report that outlines the conduct of the investigation. You want to make sure that you record the documents and the supporting documents that you're relying on. So there was a sexual harassment investigation that we did recently where there was videotape evidence that we relied on to determine the location of the parties and the timing of certain events. So that wasn't a smoking gun in the sense that it recorded a sexual assault, but it did help us to make credibility assessments. And so if you're relying on evidence, or if you've collected and reviewed evidence, you want to make sure that all that information is preserved and that detail is referenced in your investigation report. It's a good practice when you're meeting with parties and witnesses to have them review a copy of the statement and sign off that, yes, these are the questions I was asked and these were the answers that I gave. And at the end of the day, you want to make sure that you reach a conclusion and that you give reasons for reaching that conclusion, right? So people can see how you arrived and how the evidence that you collected, how you weighed that evidence, and ultimately how you arrived at a conclusion. So you want to make sure that this documentation is kept, that's maintained, and then that's known. So if it's internally, you want to have a policy for your investigators to follow in that regard. If you're using an external investigator, you want to let that person know, we expect you to keep these documents as a record of how you conducted this investigation. And also letting them know that they may be required to testify in a future legal proceeding, right? So like I said, whether this ends up in court as part of a wrongful dismissal lawsuit or at grievance arbitration, the investigator should know that they might be called to give evidence at that legal event. Finally, another issue that a misstep that we often see is a failure to decide. Right? So you have gone through this process. You have asked this complainant to pour his or her heart out. You have rigorously examined the responding party and witnesses, and you've gone through this entire process. And at the end of the process, you're expected to make a conclusion, right? Like, did this thing happen or not? You can't throw up your hands and say, well, it's too complicated. I have conflicting evidence and I don't really know what happened here. You know, at the end of the day, you've got to make a decision that is you have to do the best that you can with the evidence that you collected. And oftentimes these cases come down to credibility assessments, right? You got to reconcile that I have this conflicting evidence and here's the evidence that I'm going to give more weight to. You're looking ultimately for stories that make sense. And, this person's evidence was corroborated by this document or this email or these chain of text messages. And, on a balance of probabilities, I think it's more likely than not that things happened this way or the way that the complainant described it as opposed to the way that the respondent explained it. So you've got to wrestle with this evidence and come to a conclusion. At the end of the day, it's just not good enough to go through the process and throw your hands up. Now, sometimes you do reach a point where, based on what you've collected, you really don't know. And that would be an opportunity to reach out to a third party. You can contact a law firm or myself, and you can say, hey, look, here's what we've collected. Can you take a look at this for us? Is there something that we missed, or should we be going in a different direction? Is there a different question that we should have asked? And you can get some input to try and break through and get the evidence that you need in order to make a conclusion and take whatever steps are necessary from there. So that brings us to the end of the formal part of our presentation. We do have time for questions and answers. So I would ask that you use the chat function and direct your questions there, and I will be happy to take them and be able to follow through. And, we've had, some low level things where you had one employee who would just kind of mutter under his breath, like he would say about another coworker, like, what an idiot, right? Or, this person's like so stupid. And he would like whisper these things, but I guess whisper out loud. And, obviously that was problematic and troublesome for the person on the receiving end. And she complained to HR, and HR met with the responding party, and he acknowledged that he said it, and he's like, yeah, you know what, I shouldn't do that. I just got frustrated, and I just said what I felt like saying, and so these are still instances where someone has done a quote unquote, these are investigations, right? But they're on the lower end of the scale, right? It's not the big formal investigation that we all think about. Sometimes this lower level conduct can be dealt with in those informal ways and dealt with adequately and appropriately. We have another question here from Nadine. If an issue was investigated and was found to be unsubstantiated, but the employee is not happy with that finding and puts in another complaint, are we obligated to conduct another investigation? That's a great question. You often have, at the end of a process, someone who believes that, that they're right and that something should have been done, and they often have very definitive ideas on what needs to be done on the back end. So it's not unusual for folks to be disappointed. If they are submitting, so in terms of that first investigation, you dealt with it appropriately, it was unsubstantiated. The second complaint comes in from the same person, and if it deals with essentially the same allegations, then no, there is no obligation to essentially redo the investigation. You've done the investigation. If they are making a fresh allegation, if there's a new event, right, like something new that happened since that first investigation, then there would be an obligation to look into that new event. But no, if they're just simply unhappy and they want to, have you take a second look into what they've already complained about, no, there isn't an obligation to do that. You can simply let them know that we've looked into these issues, and if there is something new or different that you're complaining of, please let us know if we're missing something here. Otherwise, we've dealt with that. Here are our conclusions, and we're moving on. And I think it's that moving on piece that maybe many employers don't do that well, right? Like we're quick to do the investigation oftentimes, but putting the pieces back together after an investigation is not often what comes to mind, and we don't do that. We don't really have a nice, elegant way of putting those relationships back together. So sometimes, that's what's needed, is really that meeting with the parties to bring about closure, whether that's a one-on-one with HR or a third-party mediator, or some sort of a facilitated discussion between the parties. But putting the pieces back together after an investigation, especially where the parties will continue to work together going forward, it's an important piece that warrants some thought from many of us. Yeah. A question is asked about whether or not there was any personal liability for the HR manager in this case. And in that case, there wasn't. There was punitive damages that were awarded, and in that punitive damages award of $75,000, the court looked at the fact that the HR manager just accepted what his friend had told him about what had happened, didn't do a fulsome investigation, ignored relevant evidence, did not meet with all relevant witnesses. Certainly it looked like a process that was engineered to deliver a certain result, and it did deliver that result. There was also issues of defamation, where after Elgert was dismissed, everyone knew that he was dismissed for sexual harassment. So all of those facts together, the negligent investigation and the other misconduct of the parties, led to a finding of punitive damages, but there wasn't an award personally against the HR manager in that case. Another question that we have here is, when making a conclusion, would it be better to make a recommendation opposed to stating that the accused person is guilty, or found to have done the thing that they are accused of doing? So when making the conclusion, would it be better to make a recommendation opposed to stating that this person was found to have violated the policy? At the end of the day, Janice, my take on it is that at the end of an investigation, you have to make a conclusion, and the allegations are directed towards one person or several individuals. So you're making a conclusion in terms of And so first of all, you're making a conclusion in terms of, did this person do this thing that they were accused of? Did they grope their coworker? Yes or no? And so that's number one. If they groped their coworker, does that constitute sexual harassment under our policies or applicable legislation? And so you have to make those conclusions. And then from those conclusions flows the recommendations. And I see, those things work hand in hand, right? So the recommendations are informed by the conclusions that were made, and then you transition to, okay, well, this thing happened, or so we're concluding, yes, this thing happened. Where do we go from here? And that's where the recommendations then come in terms of the next steps and what's appropriate, and how do we adequately respond to the misconduct in question. So I would, in my investigations, I've never shied away from making a clear-cut conclusion that whether or not something happened, and then usually the recommendations flow from those conclusions, or the recommendations would flow from other observations, right, that I've made throughout the investigative process. And Claudia asked a question: how would you handle a patient saying that a nurse sexually harassed her? So these are issues that come up all the time. I did an investigation where we had an X-ray technician accused of groping a patient's breasts during an investigation, during a procedure. So this is the X-ray technician feeling around and groping this patient's breast during an examination. Certainly, these are serious allegations. So you have to meet with the patient and receive whatever the allegations are, and then that would be a situation that the hospital would have to look into. The nurse would have representation there. It may be a situation where you've got a couple different things happening, right? You've got the workplace investigation to figure out whether or not this patient was sexually harassed. You also have potentially the outcome of that, and potentially a parallel investigation by the governing body, right? Who would want to look into that allegation that's been made against the nurse, and there could be implications from on the professional side as well. So, yeah, certainly, the fact that it's the patient making the allegation, it would still be something that the hospital would look into, Claudia. Another question that we've had is, in terms of an appeal process for an investigation, is there one if the employee either does not agree with the overall, is there one if the employee does not agree with the overall findings or the recommendation? The investigations have taken on this whole life. If I look back over the last 10 or 15 years, right? You look back 15 years ago, and they were prevalent, but not as prevalent, right, as they are today. And especially over the last 10 years, they're just escalated. And as I've said, there's just there's so many rights at stake, and so much at stake in terms of the consequence or outcome from an investigation. And there is no internal process unless your organization has, as part of its policies, some sort of a secondary review or a reconsideration or an appeal process, as this individual indicates. Unless there's an internal policy that would indicate that there's a right of appeal, you are really left in a difficult spot as an employee, right? Your recourse really is and the cases that we've seen is really in the context of litigation, right? Whether that's grievance arbitration or wrongful dismissal litigation. That's often how a light is shone on what the employer did or didn't do in an investigation. So there was a case with Magna a couple of years ago where their HR manager conduct an investigation and was in a conflict of interest at the time of conducting the investigation and should have recused herself from that process and had somebody else done it and do that investigation, whether internal or external. But that issue didn't come to light. It only came to light, sorry, at the Ontario Labour Relations Board, right? Like through the process of a union challenging a decision that the employer had made. So, despite the fact that there are important rights at place and that certainly employers can get it wrong, and we have a lot of examples of employers getting it wrong, at this point in time, there isn't any recourse for individuals to get that reconsideration and to make sure that this was done right, in a way that allows them to maybe keep their jobs and continue working while this process unfolds. So it really is up to the parties, up to the employer and whomever they might retain to do the investigation to get it right, because certainly a lot of folks are counting on them too. Any other questions? Well, I'm not seeing any questions come through, but I do want to thank you for your attendance here today and your robust participation and engagement. It just means a lot when you for us to be able to put together these presentations and to know that they are well received and that you are benefiting from them and able to apply the information and the tools that we are putting out there and apply them to the work that you do. So we thank you again for being part